The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about stock transfer restrictions for Illinois LLCs and closely held corporations. So, a stock transfer restriction is when owners of a company have limitations on how and when and to whom they can transfer their stock. These make sense when it's a small group of owners who want control over who they will be partnering with in the future. You want to basically minimize your financial risk, and often in a closely held corporation or LLC, it's people who already know, like, and trust each other, and that's why they choose to go into business with one another, and they don't want to be surprised by one of the owners selling stock to a third party, and now they're in business with someone they don't know. So that's why you have stock transfer restrictions. There's a couple different flavors. First is a requirement that the board or other shareholders approve a transfer of stock. Now, this can be very restrictive. It can require unanimous approval by the board or the other shareholders. It can be a majority vote. It can be a supermajority. And you really have to do what makes sense for your company if you're going to go this route based on your stockholder composition. This method gives the remaining owners the most protection against doing business with someone that they don't want to. It also avoids an emergency need to raise capital. In the right of first refusal, we're going to talk about in a moment, the company has the right of first refusal to purchase the stock, but they still have to come up with the money to do so. If the owners don't want to purchase the stock because the company can't afford it or the individual owners can't afford it, they can simply deny the sale. And that leads to the downside. This can lead to an owner being held captive by the other owners and forced to sell their stock to the other owners at a reduced value. So if you've got three owners, one of them wants out of the company for one reason or another, and he or she wants to sell her stock to a third party, the other two owners could say, no, we're not going to approve the transfer. And you can sell it to us, though, but we're going to pay a significantly reduced price, lower than fair market value for it. And that can definitely be an unfair situation to be in. So you can temper this situation by having a requirement of owner approval combined with a requirement that if the owners deny their approval, they purchase the stock at a certain reduced price. So it might be whatever the market value of the stock is, the owners pay 60% if they're not going to approve the sale to a third party. If the owners don't want to even pay that reduced price, then they can approve the sale to a third party. If they do want to pay the reduced price, then the person who wants out of the company gets to get out of the company without being really held captive. Everyone sets in advance what the reduced price is going to be, and it leads to less acrimony because this is something that you've agreed upon from the beginning. But requirement of approval really should be combined with some sort of out, because otherwise you have that situation where someone's being held captive, and that can lead to destruction of the company and lawsuits. You don't really want an owner that doesn't want to be there. You want to have some out for them, otherwise it's a negative for the company. So the second method is a right of first refusal, and this ensures that the owner will be able to sell his or her stock for market value. The right of first refusal is the owner goes and finds a third-party purchaser for the stock, and the remaining owners or the company have 30 to 60 days. You can set whatever time period you like to give the selling owner notice that they want to purchase the stock at that price. So the good news is that the owner that wants to sell their stock is going to be guaranteed the right to sell it. They just might have to sell it to the company rather than to a random third party, and that is usually not a negative for them. The downside of this method is that it does require the remaining owners that want to purchase the stock to raise capital to purchase the stock if they don't want to be partnered with someone that they don't know, like, or trust. So they're at a risk of either having a situation where they have to raise a bunch of money they weren't expecting to have to raise in order to buy this stock, or be partnered with someone they don't want to be partnered with. This problem can be tempered by using a promissory note, where you provide in the buy-sell agreement that deals with this, or the operating agreement, that yes, there's a right of first refusal, but if the owners choose to exercise this right, it can be done over the course of 5 to 10 years. And the stock might transfer right away, but there's a promissory note that uses the stock that's transferred as collateral in order to pay for this over the course of 5 to 10 years or however long you want to set. That allows the owner that wants to sell to ultimately get fair market value, because there'd probably be interest on the promissory note, ultimately get fair market value for the sale of their stock, the ability to leave the company, but it also solves the problem of the remaining owners having to come up with an emergency cash call in order to afford to buy the stock. The final thing we'll talk about is the mandatory purchase by the company or the other owners of an owner's stock. This can occur when an owner dies or becomes disabled. The owners may want to require that the stock be sold back to the company because they don't want to be doing business with the spouse of the owner that died or the heirs of the owner. So they may require the stock to be sold back to the company, but the company, on the flip side, may be required to purchase it at a certain agreed upon price. And this is usually funded through life insurance. But there's other situations that have a mandatory buyback, and it's kind of exclusive both ways. So the person who's selling the stock has to sell it to the company, but the company has to buy it at a given price. Another situation where you might do this is retirement. And this is basically, if someone's been working for the company for a certain amount of years, it can create an internal pension plan for a small business. I mean, it's not technically a pension, but it is a way for, like the sale of stock with the right of first refusal, you may provide for a promissory note over a long period of time. You value the company's stock at a certain value, and when someone has hit a certain benchmark that allows them to retire, they give the company X amount of months' notice, and then the company is required to purchase the stock either at a lump sum or over the course of time through a promissory note. And this is all agreed upon in advance, and it gives a graceful exit from the company for people who are aging out or want to retire or who have hit certain benchmarks. Retirement and death or disability are the most common times that this is used as a standalone stock purchase restriction. So just saying you can't sell to anybody but the company has to buy it. Those are when it's used as a standalone. It's used often in combination with the requirement that you get shareholder or board approval or a right of first refusal. Well, not really a right of first refusal, but shareholder or board approval. Like we talked about earlier, if the shareholders or the board deny the transfer of stock, they may be required to buy it back at a reduced rate if they don't want to allow a sale to a third party. So if you have any questions, you can leave them in the comments section below this post at learn-about-law.com or below the video on our YouTube station. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have offices in several geographic locations for your convenience. If you found this helpful, we'd love it if you'd subscribe on Apple Podcasts or on YouTube or on SoundCloud or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.